Welcome to the Deep Dive, where we cut through the noise and get straight to the knowledge. Today, we're plunging into a topic that, well, it touches everyone eventually, but often remains kind of mysterious. Probate. That legal process that steps in after someone passes away. Validating wills, paying debts, distributing assets. Now, it might sound straightforward, maybe just a bureaucratic step, right? Write a will, it gets executed. Simple. But as you'll discover from the sources you've shared, especially those excerpts on probate, federal and state variations, that's really not the full picture. Our mission today is to sort of pull back the curtain on this complex dance between federal oversight and, frankly, a dizzying array of state laws. We want to uncover the critical differences and hopefully give you those aha moments you need to feel, well, truly informed, maybe even empowered. Yeah, we're talking everything from federal state taxes to some surprising ways your wishes might get overridden. It's not always a one-size-fits-all thing. So let's untangle this sometimes surprising, often complex landscape. Okay, let's unpack this central tension first. When we think about probate, it's easy to imagine like one big federal system for everything. But that's a common misconception, isn't it? The federal government isn't really running the show here.
That's absolutely right, and it's a crucial distinction to make right off the bat. What's fascinating is that the U.S. federal government, it doesn't actually have a centralized probate system. Not at all. The actual probate process, the nitty-gritty of authenticating wills, appointing executors, managing the estate, that's almost entirely handled by state courts.
State courts, okay.
However, federal law absolutely comes into play, primarily through taxes. Significant influence there.
Ah, okay. So the states handle the how, the mechanics of it all, but the feds are interested in the what? Especially the financial side?
Precisely. Yeah, the most significant federal involvement, for most people anyway, is the estate tax, sometimes called the death tax, but it's technically a tax on transferring property at death. And for 2025, the federal estate tax exemption, and this includes lifetime gifts too, it's quite substantial. We're talking around $14 million per person.
Wow, $14 million. That is a huge number. I imagine for many listeners, that figure alone might be a big relief. Like maybe federal taxes aren't their biggest worry.
You're right. For the vast majority of estates, federal estate tax won't even be on the table. They'll be below that threshold. But, and this is important, for estates exceeding that $14 million mark, a tax rate of up to 40% can apply to the amount above the exemption.
40%. Ouch.
Yeah. So for those very large estates, filing IRS Form 706 is a critical and often complex undertaking. It's also worth mentioning individuals can use strategies like making lifetime gifts to reduce their potential taxable estate. But, that's a whole other conversation.
Right, another deep dive, perhaps. Okay, that clarifies the federal tax part. But this brings us to something that often, well, it blindsides people. It's where even a carefully written will might not do what you expect. What about things like retirement accounts, beneficiary designations? I hear there could be some real twists.
Oh, that's a fantastic point. And honestly, it's where countless estate plans, even with the best intentions, can just go completely awry. It raises that key question. What actually controls how an asset gets transferred? For things like IRAs, 401ks, life insurance policies, even payable on death bank accounts, the beneficiary designation you fill out on that specific account paperwork, that is paramount.
Paramount how?
Those designations are basically binding contracts. They legally supersede, they override whatever your will says about that specific asset, even if your will says something totally different.
Wait, hang on. So if my will says my spouse gets everything, 100%, but an old 401k form I forgot about still, I don't know, my brother.
Your brother gets the 401k.
Seriously. Regardless of the will.
Exactly, regardless of the will. It's a powerful and often shocking distinction for people. So if someone named their daughter as the IRA beneficiary, those IRA funds pass directly to her. They don't even go through probate. It doesn't matter what the will says about those funds. The paperwork with the financial institution is the final word.
That is a huge aha moment right there.
Wow.
So keeping those forms updated is critical.
Just as critical as updating your will, absolutely. And there are other federal laws, too, like for certain veterans benefits or government bonds that have their own transfer rules outside of standard probate. It's a stark reminder, really. Your intent isn't enough. The paperwork has to match that intent.
Okay, so federal layer, big taxes for large estates, and these specific beneficiary rules. But the actual mechanics, the sorting out, that's squarely in the state's court. Which suggests, I guess, a huge amount of variation across the country, like a real patchwork of rules.
That's absolutely right. A patchwork is a great way to describe it. And this is where the complexity and maybe the potential for confusion really ramps up. Each state, California, Florida, Texas, New York, they all have their own unique probate code, their own set of laws. Now, about 18 states have adopted something called the Uniform Probate Code, or UPC. Parts of it, anyway.
Wait, what did that do?
It tries to harmonize some procedures, make things a bit more consistent. But that still leaves, 32 other states? Many of those rely on older statutes, sometimes very individualized with really specific rules. You just cannot assume that what holds true in, say, Arizona is going to be the same in Massachusetts.
Which means for you, the listener, understanding these state differences isn't just like academic knowledge. It's crucial for your planning. Crucial to avoid pitfalls. Let's dive into some of those key state variations then. What should people be aware of?
Definitely. Okay, one big area is small estate procedures. Lots of states recognize that full probate can be, burdensome, expensive, and time-consuming. So they offer simplified procedures, maybe just using affidavits, sworn statements for smaller estates.
That sounds like a big help for many families.
It can be, yeah. A huge relief. Helps heirs get access to assets quicker and cheaper than formal court proceedings.
What kind of thresholds are we talking about? Like what qualifies as small?
Oh, it varies dramatically. Really dramatically. Texas, for instance, I think their law allows estates under about $75,000 to skip formal probate using affidavits, but other states, the limit might be much lower, maybe just a few $1,000s, or maybe they allow specific things, like a car, to be transferred with a simple form. It's really a spectrum. You absolutely have to check the specific rules for the state where the person lived.
Got it. Check local rules. Okay, what about protecting the immediate family? Does the state step in to make sure a spouse or kids are taken care of, even if the will doesn't?
Yes, they often do. These are generally called homestead and family allowances. Think of them as a crucial safety net. Many states protect the primary home, the homestead, from creditors up to a certain value. And beyond that, they often provide a statutory allowance, basically a set amount of money or property.
Like guaranteed money?
Guaranteed support, yes, for the surviving spouse or minor children. And here's the key part. This support is often given before creditors get paid, and sometimes even before specific gifts in the will are handed out. The details, though, like the homestead exemption amount, or what's called the elective share percentage.
Elective share?
Yeah, that's a portion a surviving spouse can legally claim from the estate, even if the will tried to leave them less, or nothing at all. Those percentages vary widely state by state. For example, a state might just mandate that, say, at least 1/3 of the estate must go to the spouse, no matter what the will says. It's a powerful protection.
So the law can basically say, hang on family first, overriding the will's instructions to some extent. That is significant. Okay, what happens if someone dies without any will? Intestate, right. That's where state rules completely take over, I imagine.
Precisely. That's where intestacy rules kick in. If you die intestate without a valid will, the state doesn't just guess what you wanted. Every single state has its own specific law, a statute of succession that acts like the government's default will for you. It dictates exactly who inherits and in what proportion.
And I bet those default wills vary a lot too.
Oh, massively. For instance, take Arizona. It's a community property state. There, a surviving spouse typically gets half of the deceased's separate property stuff owned before marriage, or gifts inheritances, plus all the community property assets earned or acquired during the marriage. The kids get the rest of the separate property. But go to a different state, maybe a common law state. The rule might be totally different. The spouse might get, say, the first $50,000 plus 1/3 of whatever's left, and the kids split the rest. The outcome for the family can be dramatically different depending purely on which state's law applies.
So it's not just who inherits, but how property is even defined between spouses that's fundamentally different. Community property versus common law.
Exactly. And that distinction, community property versus common law states, is huge for married couples. In community property states, think California, Texas, Arizona, several others, most assets you acquire during the marriage are generally considered owned 50-50, automatically.
50-50, okay.
So half typically passes to the surviving spouse, maybe outside probate if titled right. But in common law states, which is most states, there's no automatic 50-50 share just because you're married. Ownership usually follows whose name is on the title, or who earned it. A surviving spouse in a common law state generally only gets an automatic share if the will gives it, or through those elective share laws we mentioned. It's a fundamental difference.
That's critical to understand. Wow. Now, what about, say, a vacation home, or owning property in multiple states, does that just multiply the headache?
It certainly can, yes. This triggers something called ancillary probate. If you own real estate,
Yeah.
a condo, land, a house in a state that's not your primary residence, your domicile.
Like a snowbird with a place in Florida.
Exactly like that.
Wow.
Then you might need an additional separate probate proceeding in Florida, as well as in your home state. Potentially one in each state where you own real property.
Oh boy. So separate court cases, different lawyers maybe?
Often, yes. Entirely new legal actions, different filing fees, different local rules, sometimes running at the same time as the main probate. It adds significant layers of complexity and cost.
Right, so owning property across state lines isn't just a lifestyle choice, it's a major estate planning consideration. And speaking of costs, the fees, the deadlines, I assume those vary too.
You assume correctly. Probate fees and deadlines are another big area of state-by-state difference. Court filing fees can vary. Attorneys' fees, how they're calculated or approved, can vary. And timelines. One state might require a will to be filed with the court within, say, 10 days of death. Another might give you 30 days or even longer. Some states even set executor fees by law, like a percentage of the estate. Others leave it to the court to decide what's reasonable. You absolutely have to check the local court rules.
Local rules again, it keeps coming back to that. And finally, taxes. We talked federal state tax, but states can pile on too, right?
Yes, that's the other shoe that can drop, and it often catches people by surprise. Many states, roughly half, as of 2025, impose their own state or inheritance taxes. And notice the two types. An estate tax is on the total estate value before it's distributed. An inheritance tax is paid by the person receiving the inheritance, and rates can vary depending on their relationship to the deceased.
So it could be one or the other
Or even both. Maryland, for example, uniquely has both an estate tax and an inheritance tax. Other states like Oregon, Massachusetts, New Jersey, they have estate taxes, often with much lower exemption thresholds than the federal one. These state taxes generally have to be dealt with during the probate process, adding another financial layer.
Wow, okay, that is a lot to keep track of. Federal taxes, state procedures, beneficiary forms, property types, state taxes. So if we try to tie this all together, bring it back to the big picture, what's the number one takeaway for you from all these variations?
That's a really important question. I think the core message fundamentally is this. While federal law sets the stage for big-ticket taxes and handles some specific asset transfers like those beneficiary designations, the vast majority of the actual probate process—
Day-to-day stuff.
Right, how it actually works, the specific outcomes for beneficiaries, who gets what according to intestacy, family allowances, that is overwhelmingly governed by state law. It is absolutely not a one-size-fits-all system. It's a complex mosaic of regulations.
So you can't just read a general article online and assume it applies where you live.
Exactly. Anyone planning their estate or anyone stepping up to be an executor, which is a tough job, you absolutely must consider both sets of rules, federal and state. Specifically, your state. Neglecting either one can lead to delays, unexpected taxes, higher costs, and sometimes, sadly, your final wishes not being carried out the way you intended.
It really drives home why understanding these differences is so critical. It's not just about legal boxes to tick, it's about peace of mind. Avoiding those nasty surprises and making sure your legacy is handled correctly. Knowing the specific rules that apply to you. This deep dive has definitely shown us just how complex probate can be. It's not just procedures, but fundamental outcomes that change state by state. Who inherits, how much tax is paid, even how fast things get done. And thinking about that intricate dance, federal versus state, and all those unique state rules, it really makes you wonder, doesn't it? Given these profound differences in intestacy, homestead, state taxes, community property, how might really understanding these varying probate landscapes actually influence someone's decision about where to officially live, where to establish their legal domicile? Especially if you have assets or families spread across different states. It's certainly something to think about further. Maybe even reevaluate based on what we've discussed. Thank you for joining us for this deep dive into probate variations. We hope you feel a little more informed now, and maybe a bit less overwhelmed by it all. We'll see you next time on The Deep Dive.